So today, the Supreme Court handed down a 9-0 unanimous ruling that rewrites the rules on when police may cross your threshold without a warrant. The decision reaches every homeowner in America, gun owners in particular, because it redraws the Fourth Amendment line you thought you knew. Smash that subscribe button right now. The scenario I'm about to unpack could be knocking on your door tomorrow. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearms statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. The instant holding and why it hits home. On direct review, the court decided officers possessed an objectively reasonable basis to enter Trevor Casey's house without judicial authorization, so every scrap of evidence found inside stays in play. From Maine to Maui, law enforcement now has an unmistakable green light to step inside without a judge's signature when an emergency label can be pasted on the call. We're talking about a precedent that touches every front door, every gun safe, and every American who still believes the phrase, "a man's home is his castle," actually means something. Under the Fourth Amendment, at least the version we thought we had, the facts that triggered the earthquake began in Montana. Casey's former girlfriend phoned 911 saying she had a terrible feeling after a phone argument. She thought she maybe sorta heard him mention a firearm and feared he might hurt himself, or maybe even shoot the cops who showed up. 4 officers rolled to the scene with the ex in tow. Once there, she backpedaled. She couldn't recall his exact words, only that something felt off. For 40 minutes, the officers circled the house, knocking, yelling, shining beams through windows, trying to raise him. Through the glass, they spotted an empty pistol holster on a table and a yellow legal pad. Casey never answered. But what happened next inside the courthouse is what catapulted the file to 1 First Street. The Fourth Amendment showdown. Let me walk you through the constitutional knife fight that erupted after Trevor Casey was shot and cuffed inside his own living room. Prosecutors charged him with several crimes. His lawyers fired back with a single, lethal argument. The warrantless entry violated the Fourth Amendment's shield against unreasonable searches, so the handgun recovered from a bedroom laundry basket and everything else had to be tossed. The Fourth Amendment is the original privacy deadbolt. It says the people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. For 2+ centuries, courts have repeated the mantra, "Your home is your castle," and agents of the state generally need a warrant signed by a detached magistrate before they may breach the walls. Still, judges have whittled out narrow categorical exceptions. One is dubbed the emergency aid or community caretaking doctrine. Police may enter if they reasonably believe someone inside faces imminent peril and needs immediate rescue. That carve-out is where the Montana Supreme Court slipped up, triggering today's reversal. The Montana misstep. By a 4-3 vote, the state high court sided with prosecutors, letting the evidence stand. The flaw? It applied the wrong yardstick. Instead of using the test the U.S. Supreme Court had already locked in, the Montana court borrowed the looser, reasonable suspicion standard, the same one cops use for a quick street frisk, not for kicking down a door. Reasonable suspicion is a low fence. Specific facts that make a reasonable officer think crime or danger might be afoot. Probable cause is higher. It demands a fair probability. By dropping the bar to reasonable suspicion for warrantless home entry, Montana effectively lowered the drawbridge for every future raid. The correct rule had been nailed down in 2006 in Brigham City versus Stewart. Officers may enter without a warrant when they have an objectively reasonable basis to believe an occupant is seriously injured or faces imminent threat of such injury. So the question becomes, what does objectively reasonable look like when armed agents are standing on your porch at midnight deciding whether to come in uninvited? The oral arguments and tea leaf reading. After listening to the advocates spar earlier this year, court watchers predicted the case would turn on one issue. Did Montana faithfully apply Brigham City? The justices hammered both sides on what objectively reasonable means in real time and how it differs from its cousins, reasonable suspicion and probable cause. Defense counsel insisted the ex-girlfriend's report was too hazy. No direct threat, no timestamp, no corroborated cry for help. They reminded the court that a citizen's refusal to answer his own door is not a suicide note. State lawyers countered with a stack of worrisome bricks, a hinted threat of self-harm, a holster minus its pistol, Casey's documented mental health struggles, and 40 minutes of radio silence. They argued that forcing officers to wait for a blood-curdling scream would gut the emergency aid exception. Pundits sketched two likely endings. Either the court would ship the case back to Helena with instructions to use the right test, or the justices would apply Brigham City themselves and rule on the facts. The unanimous ruling, line by line. Today, the court chose door number 2 and went further. Justice Ketanji Brown Jackson wrote for a court that voted 9-0, ideological bookends included. Rather than remand, the justices performed their own post-mortem and declared the entry lawful. The court held that police do not need probable cause to enter a home without a warrant when responding to a genuine emergency involving potential harm to an occupant. It reaffirmed Brigham City. If officers have an objectively reasonable basis to believe someone inside is seriously injured or about to be, they may go in. That standard is neither the low limbo of reasonable suspicion nor the high jump of probable cause. The opinion swats away 3 arguments. First, it rejects Montana's flirtation with reasonable suspicion, calling the standard too squishy for house entries. Second, it refuses Casey's invitation to demand probable cause for all emergency entries, explaining that probable cause is tethered to criminal investigations, not life-saving missions. Justice Jackson writes that the Fourth Amendment does not require officers to stand idle while someone inside may be bleeding out. The test is objective. What would a neutral observer think, not what secret hope lurked in an officer's heart? Why the court said the entry passed the test. The majority ticks off 4 concrete facts. 1. Officers responded to a call from a person who knew Casey well and had just spoken with him. Her distress was palpable enough that she drove to the scene with police. 2. Several cops on the call had prior contacts with Casey and knew of his mental health history, so the tip didn't come from outer space. 3. The empty holster seen through the window corroborated the firearm angle. 4. 40 minutes of pounding and shouting produced 0 response. While silence is not a crime, it can feed an objectively reasonable fear that the person inside is unconscious or worse. What this does to your rights starting tonight. From this day forward, every police academy will teach the objectively reasonable yardstick for emergency entries. The ruling is not a blank check. Cops can't crash your dinner party because they're curious. The emergency aid exception still requires an imminent danger belief, yet the court also refuses to make officers wait for a notarized affidavit of peril. They don't need certainty. They don't need to exhaust every alternative, and they don't need a judge's blessing if an objectively reasonable, life is on the line narrative can be told. For homeowners, gun owners especially, this opens a gray zone. What feels objectively reasonable will be litigated case by case, judge by judge. A bitter ex-partner, a worried neighbor, a co-worker who saw a range bag in your back seat, any of them, if deemed credible, could become the cornerstone for a warrantless walkthrough. Mental health episodes will loom large. If a relative tells 911 you sounded despondent and you own firearms, today's opinion gives police a roadmap to enter, seize, and sort it out later. Nationwide ripple effects, courts, cops, counsel. The decision will ricochet through thousands of open files. Any case where a lower court tossed evidence because officers lacked probable cause for an emergency entry must now be retried under the new old, objectively reasonable lens. Prosecutors will file motions to resurrect evidence. Defendants who thought they had won suppression may see convictions climb out of the grave. Training divisions will rewrite curricula, articulate specific, objective facts. Injury risk, mental health history, visible weapons, unresponsive occupant, and you're bulletproof. Defense lawyers will pivot from no probable cause to no reasonable basis, a harder hill to charge because hindsight is banned from the jury box. Second Amendment tremors. Expect aftershocks in the gun rights ecosystem. The nightmare scenario writes itself. Someone drops a dime that a gun owner posted a gloomy meme. Police invoke welfare check plus firearm ownership. Once inside, they confiscate every pistol under a red flag statute. No warrant, no judge, no return date. 19 states plus D.C. already have extreme risk protection order laws. Today's ruling hands enterprising officers a skeleton key. The mental health dimension is equally volatile. NIH data show 1 in 5 U.S. adults experiences mental illness in a given year, roughly 50 million people. If a distressed tweet plus gun ownership can trigger an objectively reasonable home invasion, half the country could be one bad day away from a flashbang search. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.